Now, just purely based on what we've seen on the runway at Swahili Fashion Week, the fact is that the African continent has a huge store of intangible cultural assets to draw upon, from intricate beadwork in Kenya and South Africa to colorful, vibrant fabrics in Nigeria, Senegal, Ghana, and elsewhere. But the thing is, African fashion firms often struggle to both protect and monetize that intellectual property. So to understand the challenges and opportunities for fashion firms and how they can monetize their IP, I spoke to Liz Lenjo. She's a Kenyan lawyer and a specialist in intellectual property law.
The challenge has been now to understand who would own what, because what they're trying to do is to identify a sui generis system known as traditional knowledge and cultural expressions in the fashion space, and not only in the fashion space but also in other different forms, you know, if it's medicine and all these other areas. But now the challenge would be what community owns what. So that is a very pertinent conversation, because especially in the African context, we've been very communal with the you know, our own, you know, protections or the things that we so-called own. Yeah. So case in point, Maasai beads, quote unquote. How are they Maasai beads? That's the first question.
And how do you distinguish them from, say, Zulu beads, for
exactly.
example?
And you see, the problem has been, one of the problems we're having, because Kenya, we passed the Traditional Knowledge Act in a very premature fashion. When you look at the beads actually come from China, yeah? And that was influenced from, you know, the pre-post-colonial period with the trade, the barter trade that was going on. And before, it used to be glass beads, and they became expensive, or, you know, just not easy to use. So now we are getting some of this material outsourced. So when we start saying, you know, there's Maasai beads, I mean, there's a huge question mark. And then also when you look at the traditional context, we're looking at shapes, colors, signs. Are we going to start claiming ownership for that?
But let's say, for argument's sake, that we do get to a point where the Maasai beads are recognized as something you could trademark and therefore monetize. And the government then steps in to actually say, okay, we're the default receiver, quote unquote, or whatever revenues are involved here. What would be the complexities around setting something like that up?
That would mean the communities themselves would not make money from it. And we know that, you know, the challenges of government bureaucracy. If the middleman or the, you know, the person at the grassroots is the one who's working hard to create these products, then they should ideally benefit directly. And for me, my recommendation would be, you know, have some of these communities use collective marks, you know. Divide yourselves into like small women groups or whatever kind of groups, and then find a way to brand your work and then commercialize. It's so much easier than trying to rely on government.
I'm looking at the approach that's happened in Europe. I can't put a brand like, say, champagne, right, on a bottle, unless it's been produced in a specific way with produce from this particular part of France, etc., etc. And the same applies to a bunch of other things that come through from the EU, a whole bunch of cheeses, for example.
Yeah.
I mean, given that approach that it already exists, and I know I'm jumping the gun again here, but wouldn't it be possible to at least take some elements of that and apply it to this same problem that we're facing here?
I feel like you just read the law on my behalf. There's also a protection called geographical indications, and there have been different countries that have managed to do that in the fashion sector. For example, there's a Russian lace called Ilets that is produced in Ilets, and that's something that's very smart approach. We hope we would be able to do that once we figure out, you know, what it would be that, you know, you would say the Maasai own or the Taita or, you know, all these communities. But unfortunately for now, Kenya, we've not passed the Geographical Indications Act. So we're lagging behind in some of these, you know, legislations and adopting some of these international conventions. So it stands in the way of us understanding and being able to benefit from some of these other protections.
The Maasai beads that we're talking about, some of that raw material comes through from China. And given how manufacturing is today, there's no single entity that is fully self-sufficient. There are things that will come from one end of the world, and they'll all have to be assembled in one location. Will that pose a problem down the line for the protection of intellectual property? Like, to use the example of the Maasai beads, yes, some of the inputs are coming in from China, but the way in which they're being put together, the design work, the art, the labor, a big chunk of that is happening here in Kenya. Would that stand in their way of them actually getting a trademark on it?
I think if we are cognizant of that fact, then we'd figure out mechanisms to do it better. Because right now, the law is trying to say there's Maasai beads, and in my view, there is none, you know? So when we figure out then what the protection would look like, then the better. But for now, as even our act is at the moment, is impossible. It's impractical in my view. It would hinder, innovations. It would basically say, even just by being inspired by would be an infringement of intellectual property.